Welcome to Ask the Lawyer radio podcast with attorney Brian Figeroux of the law firm Figeroux Associates. This podcast features a recording of our most recent radio show aired weekly in New York City. We hope you enjoy the show, which features news, views, and interviews on matters such as immigration, personal injury, bankruptcy, divorce, family law, estate planning, wills and probate, deed transfers, civil rights, criminal defense, workers' compensation, and taxes, both individual and business. You can contact us at 855-768-8845 or visit us at www.askthelawyer.us. You have questions? We've got the answers.
Understanding Cancellation of Removal, a lifeline in a shifting immigration landscape. Welcome to Legal Insights, brought to you by the law firm of Figeroux Associates. With offices at 26 Court Street, Suite 701 in Brooklyn, New York, Figeroux Associates is dedicated to providing expert legal guidance. Facing an immigration challenge? Call 855-768-8845 or visit us online at askthelawyer.us. Hello, and thank you for joining me. My name is Mary Campbell, legal assistant at the law firm of Figeroux, and today, we're going to discuss a critical topic for many non-citizens living in the United States: cancellation of removal. In the complex and ever-changing world of U.S. immigration law, understanding your options is absolutely vital, especially if you are facing the possibility of being removed from the country. Cancellation of removal is a form of relief that can allow certain individuals in deportation proceedings to keep their green card, or in some cases, obtain lawful permanent resident status, even if they are otherwise removable. It's a defense sought before an immigration judge, but it's not easily granted and involves strict requirements and a thorough review of your case. There are primarily three types of cancellation of removal we see in immigration court. First, there's cancellation of removal for lawful permanent residents, or LPRs. This is for individuals who already have a green card, but have been placed in removal proceedings, often due to certain criminal convictions or other violations. To be eligible, an LPR generally needs to have had their green card for at least 5 years, resided continuously in the U.S. for at least 7 years after being admitted in any status, and not have been convicted of an aggravated felony. The 7 years of continuous residence stops accumulating if you are served with a notice to appear, NTA, or commit certain offenses. Second, we have cancellation of removal for non-lawful permanent residents. This is often referred to by its application form number, EOI R42B. This form of relief is for non-citizens who do not have a green card, but have lived in the U.S. for many years and have U.S. citizen or LPR family members who would face extreme hardship if they were removed. The requirements here are even more demanding. You typically need to show continuous physical presence in the U.S. for at least 10 years before being served with an NTA or committing certain offenses. You also need to demonstrate good moral character for that 10-year period. The most significant hurdle is proving exceptional and extremely unusual hardship to your U.S. citizen or LPR spouse, parent, or child. This is a very high standard, meaning the hardship must be substantially beyond what is ordinarily expected from a deportation. Hardship to the applicant themselves is not enough under this category. The third type is VAWA cancellation of removal. This is a crucial protection under the Violence Against Women Act for non-citizen victims of battery or extreme cruelty by a U.S. citizen or LPR spouse, parent, or in some cases, a child of a U.S. citizen or LPR parent. VAWA cancellation has more lenient requirements, recognizing the unique challenges faced by abuse survivors. Eligibility generally requires at least 3 years of continuous physical presence, good moral character during that time, with considerations for the impact of abuse, and demonstrating extreme hardship to yourself, your child, or your parent if removed. Notably, the hardship here can be to the applicant, not just a qualifying relative, and being served with an NTA typically does not stop the clock on your physical presence for VAWA purposes. The process for seeking cancellation of removal involves filing an application with the immigration court, either Form EOIR 42A for LPRs or EOIR 42B for non-LPRs and VAWA cases, and providing extensive supporting documentation. This evidence needs to prove your eligibility, including your length of residence, good moral character, and the required hardship to your family members or yourself in VAWA cases. You will also have an individual hearing before an immigration judge where you and your witnesses will testify. It's important to understand that even if you meet all the eligibility requirements, the immigration judge still has the discretion to grant or deny your case. They will weigh positive factors such as your family ties in the U.S., length of residence, employment history, community involvement, and evidence of rehabilitation against any negative factors such as your immigration history or criminal record. Adding to the complexity, the current immigration landscape in 2025 presents significant challenges. We are seeing a shift towards more restrictive policies and increased enforcement. Recent executive orders and policy changes appear to be limiting prosecutorial discretion, meaning DHS attorneys may be more likely to oppose cancellation applications vigorously. There are also concerns about changes at the Board of Immigration Appeals, which handles appeals from IJ decisions, potentially leading to longer waits and a more restrictive review of cases. The high hardship standards, particularly for non-LPRs, are likely to face even stricter scrutiny. Given these complexities and the challenging environment, having experienced legal representation is more crucial than ever. An attorney can help you understand if you are eligible for cancellation of removal or any other form of relief, gather and organize the necessary evidence, prepare you and your witnesses for court, and present the strongest possible legal arguments on your behalf. They can also help navigate the procedural aspects of removal proceedings and address any complex issues, such as those related to criminal history or the stop time rule. Cancellation of removal offers a potential path to a second chance, a chance to keep families together and continue building a life in the United States. But it requires meticulous preparation, a deep understanding of the law, and skilled advocacy. If you or someone you know is in removal proceedings or has questions about cancellation of removal, don't face it alone. The law firm of Figeroux Associates is here to help. With their expertise in immigration law, they can assess your situation and guide you through the process. Visit us at 26 Court Street, Suite 701, Brooklyn, NY 11242. Call today for a consultation at 855-768-8845. That's 855-768-8845. Or learn more about our services online at askthelawyer.us. That's askthelawyer.us. Don't wait. Contact Figeroux Associates today and take the first step towards understanding your rights and options.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www